Just so I make sure you're hearing me, would you type OK if you can hear me? Mustafa, do you want to call her? I don't see any. No one has said OK. Okay, it looks like Patsy is with us and the entire audience. So we'll get started. My name is Mari Letterman. I'm a partner in the construction law group in the law firm of Murtha Kalina. We represent all of the different players in the construction industry, and by that I mean we represent owners and developers, general contractors, subcontractors, material suppliers, and some designers. We represent those players in all phases of the construction process, and by that I mean we represent these folks in drafting contracts, in negotiating contracts, in bid protests on public projects, to solve problems as they arise during construction, and in dispute resolution at the end. That means arbitration, mediation, and litigation. By representing all the different players in all of the different parts of the construction process, we have a good perspective on what each of the players needs and what they should avoid. I was counting up the other day, and my partners and I have over 200 years of experience in the construction industry, and that provides a depth of experience which allows us to be more effective, efficient, and knowledgeable advisors to our clients. The purpose of the webinar today is to help you gain the benefits of email and avoid pitfalls. In order to do this, I'm going to discuss 13 email pointers. In those 13 include the characteristics of email, its uses, and some recommended email practices. I'll be illustrating these points of view with these 13 points with actual real-life emails. I hope this will be both informative and fun. And as we proceed, what I'd ask is that if you have questions, you send them to me through the webinar, and I'll try to answer them as we go along. I'd prefer not to lecture for an hour, and I would prefer to be responsive to the questions and concerns that you have. And for that reason, I'm asking you to send your questions as we go. In addition, we'll try to leave some time at the end for oral questions. And finally, if the webinar finishes and you find tonight or tomorrow you have other questions, feel free to call or email me, and that information is on the front page. So, proceeding. Email is, let's see here, there we go. So what's the big picture of email? Email has all but replaced hard copy, both internal and external. In other words, emails, the communications that you give to your employees and superiors, and emails that you give to your customers outside. The thing about email communications, more so even than the letters that we're all accustomed to, is they're permanent. Unfortunately, many people treat email as if it weren't entitled to the same care, respect, and attention which we all gave to letters and memos. Nothing could be more wrong-headed. As I said, email is permanent. Now, if you're a computer wizard, perhaps you could be able to permanently delete email, but the rest of us should assume it's permanent. And just as a reminder, recently we've seen cases where Hillary Clinton has been confronted with prior emails, and of course Tom Brady, more with voice messages and text messages, but again, it's the same kind of permanent thing that you might find come back and either help you or haunt you later if you're not careful. This next email is an example, and all the emails I have are real life emails. I didn't make any of these up. In fact, I couldn't have made any of them up. This is an email from a fellow by the name of Jim Alchin, no idea who he is, to a fellow named Bill Gates. I'm sure we all knew who he is. And this email came out in some litigation challenging some of Microsoft's procedures. And Jim says to Bill, "Not sure how the company lost sight of what matters to our customers the most, but in my view, we lost our way." He concludes by saying, "I'd buy a Mac today if I weren't working at Microsoft." Can you imagine how Mr. Gates felt when he was confronted with this email in a courtroom? The next email is came out of a lawsuit in which a law firm by the name of DLA Piper had sued its former client for $675,000 in unpaid legal fees. When the client got the suit, it decided to countersue DLA Piper for overbilling. And these email exchanges are internal exchanges between different lawyers at DLA Piper. First one, I hear we're already $200,000 over our fee estimate. That's Team DLA Piper. Next one says, some attorney named Vince has random people working full-time on random research projects in standard churn that bill baby mode. That bill shall know no limits. And finally, it took all the associates 4 days to write those motions. Perhaps if we paid more money, we'd have skilled associates. Who do you think had the upper hand in the counterclaim by the client for excess fees after these emails were introduced in court? And again, it all has to be disclosed, and it's not going away. So the next hint, if you will, the next suggestion is to prepare all of your emails with care. And you need to use the same level of care and attention to detail that you would give to any written communication. Again, we have a tendency to think that email is informal, and so we don't pay attention. What I suggest is that you read and reread both the email to which you're responding and your response. And whatever you do, don't rely on the spell check, because that may not catch some mistakes. This first example is one that I personally wrote. I had written a previous email to a client, and after I read it, I found that I'd made a mistake because I hadn't taken my own advice and checked that first email before it went out. So I reread it and I said, oh my goodness, I made a mistake. So I immediately wrote back to them and said, "Dear Betty and Jim, my below email had an error in the second sentence of the third paragraph. Here's a corrected version." How do you think I felt after I reread this one? Don't be in the same position as I. Reread them. I must not have even done the spell check on this one. Shame on me. Next email is one that I received not quite a year ago from a friend who was organizing a video shoot at our office. We were practicing how we looked on tape, and we all spent a lot of time setting this up, and my friend wanted to make sure that everything was going to be exactly the way it was supposed to be so that everything would work properly and no one would be inconvenienced. So he said, let's talk about the food. Let's talk about catering. It will help to have a room with water, food, breakfast, and some lunch for those who will be there for a while. We knew everyone wasn't staying, but we needed to have lunch for those who were. I plan on being there all day to produce the shoot. I'd love to have an office with a wife if at all possible. Obviously, what he meant to say was Wi-Fi. So the spell check wouldn't have helped. Looking it over a second time would have helped. Needless to say, we didn't find a second wife for him. We did get him the Wi-Fi. Just checking to see if there are any questions. Nope. Okay. So we'll move on. Now, like any other recorded communication, be it a letter, a video, a sound recording, an email, a text message, a voicemail message, the email communication can be used to refresh one's memory of what happened. In other words, to remind you 3 years after you put the roof on whether it was raining that day and therefore you were delayed. Or it can also be used to show that one is mistaken, inconsistent, or biased. And the classic example is that, well, I'll show you some classic examples. What I meant to say was that the corollary to this, the other part of this, which we say, is that if it's not in writing, it didn't happen. Now, obviously, that's not true, but from long experience with courts and arbitrators and mediators, I can tell all of you that if you say something happened 3 years ago yesterday and you don't have some writing or other documentation to confirm that, no one's going to believe you, or you're going to get challenged on cross-examination. On the other hand, if you wrote an email to yourself or a text message to yourself on February 24th, 2016 and said it was a gray and cloudy day and I couldn't see more than 20 feet in front of me, then when you're having to recall that 3 years later, and quite frankly, that's how long it takes some cases to get to court or arbitration, you'll be able to say clearly, yes, I've looked at that email and now I remember that's how it was that day on February 24th, 2016. So let's look now at some examples of how emails can be helpful or harmful. This first one involves a case in which we were representing the general contractor. The owner had lost confidence in the general contractor, but he didn't fire him. Instead, he didn't fire our client. Instead, he hired another general contractor to finish parts of the work. But the owner was trying to play games and get our client to do as much work as he could get him to do, and perhaps not being straight with him. So the first email is one from the owner's representative to the owner's project manager. And he says, how and when do you recommend back charging the general contractor client? And what do you think the general contractor will do when that occurs? So the project manager writes back to the owner's rep, we don't recommend back charging the general contractor until the end of the job. Why not? Because he'll walk off the job. And this is where it gets really interesting. The same goes for change order reviews. The general contractor, our client, is proceeding with all this extra work and change orders. However, the owner has the final say. As far as we're concerned, the work is now getting done. The owner may reject any of the change orders later. And that's exactly what happened. So from this email exchange, we were able to show that the owner never intended to pay our client for all this extra work, and in fact was conspiring months before we finally got fed up and left to have us do work and not intend to pay for it. Now, another suggestion with emails is that sometimes it's better to talk than email or text or leave a voicemail for somebody. And why is that? Because, again, we get back to the fact that email is permanent. So if you're concerned that a permanent record could be used to embarrass your company, yourself, or someone else, or somehow could be used against you, it's better to communicate orally. Pick up the phone. We all have them. A corollary to this is just because someone sends you an email doesn't mean that you're required to respond by means of an email. There's no law that says that. There's no practice that says that. And so if you think it through and you decide that you don't want something permanent, then pick up the phone and call. This next two emails are involved in a situation in which we were representing the general contractor who had gotten delayed because the architect wasn't responding to his RFIs and other requisitions in a timely manner. At the same time, the owner was having a fight with the architect because the architect wanted the owner to pay him some more money. So the first email is from the owner's representative to the architect's representative. I reviewed your letter with the owner. This is the letter where the architect requests more money. Thank you. And then he goes on to say, once the project is complete, we'll be willing to discuss potential additional compensation to you. Further, we anticipate continuing to engage your firm in roles on other projects. So the owner is holding out hope to the architect that if he, the architect, hangs in there, that he'll be rewarded either with extra compensation on this project or perhaps some other projects. But the architect was having none of it, as shown by the next email, which is from the architect's representative to all of the people working for him in his office. He writes, until further notice, do not lift another finger for the project. So we got this through discovery, we introduced it, and it greatly enhanced our client's argument that the architect had been delaying and hadn't been doing things in a timely manner. Let's look and see if there are any. Just going to check and see if there are any questions coming through. Okay, seeing none, we'll move forward. Another pointer for email preparation is think first. Think before you write. Remember, the email reflects on your credibility, your professionalism, your values, your work ethic, and how much you know. So that if you think that you're saying something, make sure that it's truthful. Make sure to check back and make sure you haven't written something to the contrary a week ago or a month ago, because if you do, it's going to adversely affect your credibility and your professionalism. Another important pointer for preparation of email is that timing is everything. And by that I mean that if you send an email at the same time or shortly after an event or discussion, that's going to be considered more reliable and more credible than an email sent days later. So generally, the sooner the better, but I'm going to make some comments later that may cause you to wait a little bit. What I'm getting at in this point is that if you have a meeting today and the other side says something that's helpful to you and or harmful to them, then the best thing to do is to write an email right after the meeting and say, Dear Fred, thanks for acknowledging that we were delayed this morning because you couldn't get the gates open on time. That's going to be considered a much more credible and believable email than if you wait until next week to say that. Another point about email is that it creates a presumption. A presumption in the law means that we assume that it's true unless somebody says otherwise. So again, if you make an assertion in an email, you claim something in an email, and the person who gets the email doesn't challenge what you said in a written response, then the assertion is presumed to be true. So the classic example is that if you're in an automobile accident and you write to the other side and say, gee, I saw the light was red, and you went through the light anyhow and hit me in the side. If that person doesn't write back and say, no, the light was green, you're mistaken, then there's a presumption that what you said in the initial communication is true. It doesn't mean that you've proven it. It can be challenged, but it gives you a leg up on the other side. So going back to my previous example, if you write to the general super and say, the gates weren't open at 7 o'clock as promised, and therefore my guys were delayed until 8 o'clock getting into the project, that's going to go a long way towards proving that you were delayed by the general. Unless, of course, the general writes back, and then you're back to square one. So let's look at an example of a situation in which could you hold on for a second, please? Should I answer this? Sorry, I wasn't sure whether that was a message from the folks running the seminar or someone else, and it was someone else. So this next example, again, a real-life email, we were representing an abatement subcontractor on a huge project, and we were getting a lot of negative feedback from the environmental expert who had to examine our work on a regular basis and say if we were doing it right or wrong. This is an email from our client to the so-called expert, or one of the experts. And there's some good things about this and some bad things about it, so I'll talk about both. Darren, this is the so-called expert. It's incredible. It's amazing to me that an individual wearing penny loafers who spent less than 60 minutes in the building could find so many deficiencies when 4 independent certified project monitors working in the buildings for over 10 hours the same day didn't find them. Bias is obvious and evident. So the good part of this is that our client very quickly called to task this so-called expert and showed that it would have been difficult, if not impossible, to find so many problems when people, his equivalent, hadn't. The expert didn't write back, and so there's a presumption that what we said was true, namely that he only spent 60 minutes in the building. Now, obviously, there's some things in here that I wouldn't recommend you put in an email. Whether he was wearing penny loafers or construction boots doesn't really matter. It's just snide. And the comment at the end, bias is obvious and evident, is not even necessary. If anything, it detracts from the thrust of the email. So you don't have to be calling names. You don't have to be labeling things, because in fact, it's clear just from the facts that this guy either didn't know what he was talking about or was out to get us. Next thing about email, and this is something that quite frankly I've gotten from the email experts out there, but it turns out to be true in my experience. And that is that email provides a much less pressured way to ask someone to do something that might be difficult for them. Unlike an oral request, in other words, unlike when you call someone on the phone or go to see them in person, the recipient has time to consider the request and is more likely to respond positively. So in a real-world example, if you want the general contractor or an owner to give a time extension or to forgive lateness, you're much better off emailing it to that person than asking him orally, because the person's immediate reaction is going to be no. Whereas if you explain why you need the time extension, then that person has the opportunity to think about it, reflect on it, and is more likely to give you a yes answer, which obviously is what you want. So take the time, write it down, and be patient. Let's check and see if there are any. Okay, so another characteristic of email that you want to be aware of, and this is probably evident in some respects already, is it can help your opponent. It can assist your opponent's proofs and defenses. And again, you have to assume that it's going to be disclosed in litigation or arbitration, because the rules of court and the rules of the AAA require disclosure. But don't think about this too narrowly. We, and I'm sure you, engage in a lot of mediations, either formal or informal, where either you're talking directly to the head of the general contractor or your client, the owner, and you're trying to convince them to do something. And if you have an email record to help that, it may, if anything, help you avoid arbitration or litigation and get things done more quickly. So it can help them, it can help you. So let's look at an example. Again, this is from the case in which we were representing the abatement subcontractor on a huge abatement project. And the general contractor finally thought that we couldn't do anything right, and he decided that he was going to terminate us. So he followed a lot of the suggestions that I've made so far, in that he was very careful to read over what he was going to do and get all the details right. So he says, this is part of his termination letter. This is like one paragraph of a 3-page letter. Please treat this letter as formal notification of termination of contract number, and he lays out the whole, 12-digit number. Doesn't make any mistake. Make sure he gets every letter and every number exactly right and in the right order. And that this 3-day notice period is effective today, because the subcontract required a 3-day notice period. So he makes sure, he says it's effective today, Wednesday, July 25th, 2007, and the period concludes at 5 p.m. Monday, July 30th. Nothing is left to chance. Nothing is left to question. We know exactly when the period starts. We know exactly when it ends. We know exactly what subcontract he's talking about. Perfect, right? Wrong. It turns out that our subcontractor had 2 subcontracts with the same general contractor, and the general contractor forgot to write a termination on the second subcontract. So he was careful, but he wasn't. As a result of his lack of care, when we got to mediation, we introduced this letter, highlighted this portion, proved that he hadn't terminated the other subcontract, and that fact alone allowed us to get much more in settlement than we would have otherwise. So again, it can help you, it can hurt you, it can help the other side or hurt them. Now, the other thing that be aware of is that emails nowadays can do things that formerly required pen and ink. So this is a decision from a judge in Boston, a federal district judge, when he was asked to decide whether there was a settlement accepted. And he said both parties clearly expressed mutual assent to the terms of the settlement when one attorney wrote in an email that, quote, the plaintiff will accept the defendant's settlement offer. And the other attorney wrote, glad we were able to get it done. The judge said, that's enough. It's a written communication. The terms were clear, and even though it was in an email rather than in a letter form, which was what was required by the contract, it's enough, and we're going to accept it. The bottom line on this is that these days courts are giving little, if any, distinction between a letter and an email and a text message. They're all equally enforceable. And what I've seen, you're all aware, of course, that your subcontracts and contracts require notices to be given to the other side. For example, if you feel you've been delayed, you need to give them notice. If you feel that you're entitled to extra work, you need to give written notice. Typically, the contract will say the notice needs to be in writing and sent by certified mail or some form of overnight delivery. Courts are ignoring those procedural requirements. They're saying, we don't care if the contract says certified mail. We don't care whether it says FedEx. If it's done in an email and you can prove that it got to the other side, which isn't difficult electronically, that's enough. So this gives you an advantage of not having to wait until you get back to your office. If you see something going wrong on a project site, you can immediately send an email to the general contractor, the owner, saying, it's raining, I couldn't work. I expected that you would have delivered the roofing materials by today so I could put the roof on. It wasn't there. Email, like other writings, can cause what we in the laws biz call a waiver. That means that you're giving something up, that you're agreeing not to proceed on something. And one of the things that causes us great concern is the disclosure of confidential information, privileged information, things like client lists or internal communications that you don't want to see the light of day. Even if you don't intend to disclose it, it's inadvertent, this can result in the waiver of confidentiality or privilege. In this case, on the example that's on the screen now, this is another email from the case involving the asbestos abatement sub arguing with the general contractor. This email arose out of a situation where the general contractor had been complaining that the abatement sub didn't do its work on time, didn't man the job properly, and were accusing us of doing things that were delaying the project. The head of the abatement sub decided that perhaps the general contractor was correct, so he wrote to his project super and he said, enough is enough. I've heard a lot of promises. Now it's time to back it up. I want a schedule showing start dates, completion dates, and crew sizes for all these different areas. So the head of the sub is saying to his project super, you guys haven't been manning it properly. You haven't been following schedules. You haven't been turning in schedules. Make sure you do it right. In an effort to show the general that he was being responsive, he sent a blind carbon copy, BCC, to the general contractor. So that may have been good in the sense that the sub's president was showing he was responsive to the general's concerns, but it was bad because this, in effect, is an acknowledgement or recognition that the sub wasn't performing on time, staffing the project properly, and so this came back to haunt the sub in the long run. So, and this is kind of one of those pointers that I've been talking about throughout, which is quick responses are more likely to result in mistakes, and my own emails have shown you that. So the suggestion is that you review and think carefully and critically about what you're writing and what you're responding to, so that you're absolutely sure that you're responding to the issue raised. And if you're not, by the way, say, gee, the first response should be, I don't understand what you're saying, please help me out, so that you're not responding to something that wasn't asked or wasn't requested. And do that before you hit send. And then what I've put in bold here is allow a 24-hour cooling off period. I can't tell you how many times I've written emails one afternoon, printed it out so I can think about it, read it the next morning, and realize that it's not clear, it's not to the point, I left things out, I put too much in, and so the cooling off period is really important. Part of this is that I think many of us believe that because someone sends us an email and we receive it almost instantaneously, that we have to respond instantaneously. You don't. There's no law that says you do. There's no practice that requires you do. So do yourselves a favor and think and write it out. Look at it again the next morning. You'll be surprised at how much good that does you in the long run. Here's one that I'm sure somebody wished they'd thought about. In this case, we represented the general contractor who maintained throughout the project that the architect's plans weren't clear. In the litigation, we received this email, which is from one employee of the architect's firm to another. And it says, I feel like every time I go to reference the drawings, I find something else wrong. I was looking at Al's lighting plans with Thomas. We could not find his lighting legend that corresponds to his plan. If we can't, how can the contractors? Proof that we were right. Couldn't ask for a better smoking gun. Again, I think if the architect's employee had thought, he either wouldn't have written it or would have called or certainly would have changed it so it couldn't come back to haunt him later on. Next point I would make is that we all need to write professionally. Emails containing capital letters, bold type, criticisms, embarrassing information, or foul language are just not well received. And the way I like to judge this is, and I was taught this a long time ago, is that imagine that your email is going to be posted on the front page of the Boston Globe or the New York Times or put online the Huffington Post the next day. Would you want to see that email published in that manner? And if you can honestly say yes, go ahead and send it. If you can say no or you're not sure, then you better think about it, because it can hurt you if you do. So here's an example of a subcontractor who's been asked to do some extra work by the general, and he's in the top email. He's saying, "Here's the sketch we provided for dealing with the ML3, which is some extra work in the north bag room. Please confirm we'll proceed with quoting the change and getting to put this to bed." The contractor's PM writes back, "Don't try to dick us on the pricing. Your engineering costs are way overblown." This is hardly professional. You'd never want to see this on the front page of the Globe or the New York Times. And how do you think this project manager felt when he was on the stand in the litigation and was confronted with this email? It completely undercut his credibility on lots of things. Don't do that to yourself. Don't do that to your employer. And just one other point about bold type and capital letters. It's like shouting. So, and at least that's how I interpret it. If someone writes to me, sends me an email or bold letters, he's shouting with me. I don't like people to shout at me. You probably don't like people shouting at you, and so don't shout at them, because it could become a problem. Just going to check for a sec. Okay. Next, and really this is the last pointer, hitting reply all is very, very risky. You should only use a reply all button if you're absolutely certain that the email is not going to go to someone that you don't want to receive it. We in our office have software that makes us take a second look before something goes out on a reply all. If you don't have that, I'd recommend it. Personally, if I have any questions, because frequently you don't know who it's going to, I send a new email addressed only to the person to whom I want to send it, and don't use reply all, because, as we said here, using the button inadvertently has created legends and problems. This is an email, again, between the asbestos, the abatement sub, and the general contractor. The first one in the series is at the bottom. This is from the general contractor back to the sub, who had sent out an email to all the general and all the other subs. And the general's project manager said, "I didn't feel this information was appropriate for everyone's knowledge. What gave you the idea that you were empowered to send this without checking with me? If there are any repercussions from this, I'll hold you responsible for correcting the issues." Now, this isn't the most professional note either, and it's sort of high-handed, but he's absolutely right. We had no business sending an email to all the other subs and embarrassing the general. So then if you go to the top of that, the subs PM is writing back to the generals. PM, "I apologize for sending the email to all. I meant to just send it to you. If you want, I'll send you a retraction out even though the damage is done." So he realizes he made a mistake, but even he realizes that the horse is out of the barn and it's too late to close the barn doors. He apologizes, but it's too late. And obviously the response, he didn't even check it for spelling errors, so it doesn't do much to help the relationship that's already been burdened by email that shouldn't have been sent. So in summary, before you hit the send button on any email, check carefully if you've drafted the email appropriately, if it's accurate, if it's responsive to the email that you got, if it's typed correctly, if it's sent in a timely manner, if it's believable, in other words, you're not contradicting something else you said, it's concise and precise and truthful. All those things will come in to make a difference ultimately, and you need to make sure that it's done right, because our emails, as good as they are, our technology doesn't take the place of human care. So that's it, folks. If you like, you can unmute your phones now, and I'll take any questions that you might have. Patty? Patsy? Okay. Oh, can internet emails be subpoenaed? Absolutely. They're like any other document, and not only can they be subpoenaed and you have to turn them over, but the risk is that if they're subpoenaed and you don't have them, then that can be a problem. So as soon as you're aware that there might be any disputes and that emails contain communications that are relevant to those disputes, it's important that you preserve those emails in their native format. And if you have questions about how to do that, you should talk to your IP people or others outside of your organization. The reason that it's important to preserve them in case they might be subpoenaed is because if you don't preserve them, then judges are increasingly penalizing the party that failed to preserve those emails. And they're doing that by fining people, by preventing them from asserting certain claims or defenses to which the emails are relevant. So judges don't have patience with people who get rid of things arbitrarily, and so since they might be subpoenaed, make sure you preserve them. Okay, so next one. Is it recommended to always respond to all? No. Or CC'd on an email? No, it's not. You have to judge that on a case-by-case basis. If for some reason all the people who were included on the original email need to be included, then they do. Then it's good to CC everyone, but not necessarily. So, trying to think of an example. If a secretary was included on an email just for purposes of keeping track of things, you don't necessarily have to CC that secretary on the way back. Or if your email would cause a problem for you with one of the recipients, then I'd recommend that you not do that. Next question. You mentioned that there's a presumption that an email was true if the recipient didn't respond. Does that hold true if an individual involved in the situation was CC'd in the same email? That's a very interesting question. Yeah, I think it would. I think if you've received a copy of something and you know that it's not true, then I think the better practice is to respond and not take the risk that someone is going to say, oh, you knew that that wasn't true, Mr. Gunning, and you should have responded. So it's not quite as clear, but for the time involved and the risk involved, I absolutely would respond if you're not a direct recipient, but someone who received a copy. Let's see here if there's other questions. Okay, I think that's it on the questions. Do any of you have any additional questions? Okay, well, I appreciate you all taking the time to participate in the seminar, in this webinar. If you want a copy of the PowerPoint, then you can either write to me or to Patsy, and we'd be happy to send you a copy so that you can see what we pointed out today and hopefully get a few more laughs out of it. Thanks very much, and thank you for attending, and good luck to all of you. Bye-bye.